The broadcast is now starting. All attendees are in listen-only mode.
Good morning or afternoon, everyone, depending on what part of the country you're in, and welcome to our webinar, The Secrets of the Ultra Wealthy. This is Deb Erdman, and I am a trust officer and vice president with Peak Trust Company, and we are sponsoring this wonderful webinar today. Peak Trust Company is formerly Alaska Trust Company. We were founded 20 years ago. Back in 2016, we obtained a Nevada charter, and that's when we renamed ourselves to Peak Trust Company to encompass both the Alaska and Nevada jurisdictions, which we can both offer. Before we begin, I've got just some housekeeping items for everyone that is attending. We are recording this presentation, and we will be sending out a copy of the recording and a copy of the slide deck within 24 hours after this webinar. We will be answering any questions at the end, but please feel free to submit any of your questions using the panel on the right hand of your screen. And our plan is to get to as many of the questions as we possibly can, and those we can't, we will address afterwards. It is my pleasure now to present to you the presenters, and it is my honor to have Jeffrey Verdon, attorney, and Julian Movazian, hope I pronounced that correctly, present for us. Jeffrey is the managing partner of one of our Orange County's premier comprehensive estate planning and asset protection firms, the Jeffrey M. Verdon Law Group, LLP. With more than 30 years of experience in designing and implementing comprehensive estate planning and asset protection structures, the law firm serves affluent families and successful business owners in solving their most complex and all those vexing estate tax, income tax, and asset protection goals and objectives. And Julian Movazian, MBA, who is the creator of Intelligent Leverage using life insurance and is recognized throughout the insurance industry as an innovator of new ideas that have placed over $40 billion of life insurance for business and estate planning purposes with a finance premium that exceeds $4 billion, not million, but billion. So with that, I'm going to turn it over to you, Jeff.
Well, thank you, and good morning, everybody. Or I guess it's afternoon in some parts of the country that we have our listeners. For those of you who may not know much about me or my law firm, we are a boutique trusts, estates, and asset protection law firm with offices. Our primary office is in Newport Beach, California, and last year we opened an office up in the Redwood City area in Silicon Valley. Our clients span most of the United States, and we co-counsel cases with other law firms around the country. And as Barbara mentioned, I'm thrilled to be joined by my good friend and the godfather of the life insurance industry, Julian Movazian. Julian, say good morning to the group.
Good morning, everyone.
Succession Capital, Julian's company, Succession Capital Alliance, Inc., has offices in Newport Beach and Manhattan, New York. And as Barbara mentioned, Julian is the inventor of Premium Finance Life Insurance, a platform that was created and transformed how large life insurance policies are sold in the United States and around the world using a concept he calls intelligent leverage. Hopefully during Julian's remarks, he'll have time to tell us the story about how he came up with this concept, because it is a remarkable story. And share with you his ideas and how he uses intelligent leverage in the estate planning process. And one of the secrets of the ultra-rich we'll talk about today is how they buy and how they pay for their life insurance. And Julian, who generally just speaks at industry conferences, I was able to snag him out of his office a few blocks from here and come over and talk to you today about Premium Finance Life Insurance. And of course, we'll take questions at the end of the program. So let's get started. Secrets of the ultra-wealthy. You've all heard the term disruptive technology, and it means, if we can get the slide to work here, there we go, a term that explains how certain things go out of vogue and are replaced with another innovation or technology. Now, we're all familiar with these companies. For those younger listeners who may not know the story, IBM used to own the operating system for the home computer. And some pinhead at IBM didn't think people would want to have a business machine in their homes, and wound up selling the operating system to Bill Gates and Microsoft. And of course, we know how that story ended. Now, IBM's a very successful company, but you can imagine how much more successful it had been had they retained the operating system. Kodak, one of the great photography companies of our generations, it no longer exists. Why? Because they didn't see the digital camera coming and they're gone. Social media has had a profound impact on our society. We have a person in the White House today who without social media probably wouldn't have won the election. When I was a kid, Sears and Roebuck was the powerhouse retailer, and today, they're shuttering stores. So if we don't get out ahead of this disruptive technology and embrace it and use it in our own practices, we could go the way of many of these companies. I love to show this slide to my clients when they come in for our initial meeting, Einstein's definition of insanity, and then we all know it's doing the same thing over and over and expecting a different result. Often we sit down with clients who have been working with the same advisors for 20, 25, 30 years or more because that's the only person, that's all they could afford at the time they started their companies or their businesses, and they have never upgraded as they rose up the socioeconomic ladder. So if people want to change the results they're getting, they need to change the people from which they get their advice. And I think that's a very illustrative way to start a conversation with your clients. Now, the first topic I want to talk about very briefly today is decanting. Decanting is fixing broken trusts, what my friend Steve Oceans calls the mulligan trust. If you play golf and you want to take that shot over again, it's called the mulligan. Well, there are many very old trusts that your wealthy clients have that were established 10, 20, 30 years ago that have provisions in those trusts which are outdated. And with the concept of decanting, those trusts, those irrevocable trusts, can be changed and brought up to modern day terms. If the trust was set up 15 or 20 years ago when the kids were just infants, and now they're just about to graduate from college, they're about to get their first distribution, and their parents are tearing their hair out of their head because they don't want those kids to get that dough because of perhaps they're irresponsible, they're not quite at the stage where they should be getting large distributions, and the lawyer tells them that the trust is irrevocable, it can't be changed. Now, many states have provisions procedures where you can amend an irrevocable trust if you go into court and you get consent by all the beneficiaries. But that's a process that's probably very difficult in most cases and not necessarily practical. You may have beneficiaries, the parents of which or whom are worried about lawsuits, bankruptcies, tax liens, divorcing spouses. So decanting a trust, changing the irrevocable trust can be a very important undertaking for your wealthy, ultra-wealthy clients. So what is decanting a trust? Well, it's very similar to decanting a bottle of wine into a carafe, as you can see from the illustration. We're going to move the trust from the jurisdiction that does not have decanting laws. Here in California, we don't have a decanting statute. So if the trust allows for it, we're going to move that trust to the state of Nevada, for example. And we're going to create the new trust that has all the updated provisions that our clients want to have in their trust that was not in their trust when it was written 20 or 30 years ago. And then we're going to take those assets and we're going to put them into the new trust from the old trust, and the old trust goes away. That's what the concept of decanting means. Now, why would somebody want to decant? Well, you may want to extend the term of the trust. In Nevada, they have up to 365 years for a trust term if you want it to go that long. This is the second bullet point is important, changing the HEM standard to a discretionary trust. Many trust lawyers who don't practice in the asset protection area aren't aware that when you use a standard of HEMS, health, education, maintenance, and support, that standard for distributions will allow a creditor of a beneficiary to grab hold of those distributions or force that trustee to make those distributions to the beneficiary, at which time the creditor can grab them. On the other hand, if the trustee's powers are basically in the sole and absolute discretion of the trustee, the creditor is not allowed or cannot force the trustee to make those discretionary distributions. So it creates a much better asset protection situation for that trust. And so if you have trusts that are irrevocable and you have the HEM standard and you want to protect the beneficiaries from themselves, then you might want to think about amending the trust or decanting the trust to a new trust that has a discretionary distribution scheme. Many older trusts have drafting errors, confusing terms. Perhaps you want to change the governing law of that trust from, let's say, California, which is a state that I've written extensively about, which is probably one of the worst states to set up a trust, to another state, perhaps like Alaska, Nevada, Wyoming, some of the other states that have come on board that have much better law for the kind of work that we do. You might want to decant the trust to change the powers of appointment. Perhaps beneficiaries have special needs and the trust doesn't qualify for the governmental benefits. And then you might have S corporation stock, which the older trust doesn't have the appropriate QSST provisions or the other provisions that would allow S corporation stock to be held by this irrevocable trust. Okay. So Julian, life insurance. Most people hate the subject. Most people turn away from it, but life insurance in the estate planning world that you and I work in is a very important asset class. And until you came up with your concept, there was really only one way to pay for life insurance. And then when you came up with the intelligent leverage of the premium financing concept, it really kicked over the table in a very old and stodgy industry. So tell us about premium financing, and maybe you can start by telling us how you came up with the idea.
Well, since we have a short time, I'll give you the short version. In 1995, one of our clients, when my office used to be in Beverly Hills, California, one of our clients, his annual premiums, they were purchasing a large policy on mom, and the annual premiums were around $800,000 a year. However, the client had issues of writing the check of $800,000, and that's when actually it was a client of mine's idea that suggested to finance the premiums. I was fortunate enough to partner up with a Fortune 20 company in 1995 that they believed in the concept, and we came up with the concept of loan for life, and that's how this whole thing started and changed the landscape in the life industry. So we call it intelligent leverage, gentlemen. So what is intelligent leverage?
There may be a few ladies out there too, Julie.
And ladies, I apologize. So it's an alternative funding method used to purchase life insurance that offers the high net worth individuals the power of choice. Most of the super affluent clients, they don't want to write $500,000, $1 million premium checks. However, when we offering them a choice, that's when the clients feel much, much more comfortable and, of course, has the flexibility. The benefit of intelligent leverage, ladies and gentlemen, is this. Everything we do, it is custom designed and flexible. It significantly increases the internal rates of returns at death and the cash value. We also create a new asset class within the trust that is liquid and not subject to state tax. Everything we do, there's no prepayment penalty, and that's a key feature, all fees on these loans. Considerably discounts the cash flow necessary to purchase the large amounts of life insurance. So, what are the applications of intelligent leverage? Are obviously estate planning and asset protection. What we've seen in the last several years, most applications that we receive from around the country for clients, we're seeing them coming in Nevada applications that trust established in Nevada. So most of these policies are owned by a Nevada trust. So it is used obviously for estate planning, asset protections, and so forth. So how does intelligent leverage work? So again, we're providing the client a choice between paying cash or leveraging it or financing it. So the benefit of intelligent leverage is this. If we have a male, for example, 65, that's purchasing a $10 million policy, over life expectancy, the client or the trust would pay $3.5 million, and life expectancy, the internal rates of returns and the death benefit, it's 9.6%. However, if we use leverage, the client will be spending $1,188,000 based on the current rate, and the client will save that, or the trustees will save $2.3 million in actual cash premiums. So the IRRs, it's 19.7%, and we discounted the client's cash flow by 66%. Another model, which is today, this is a very popular model that we've seen. We've seen clients between ages 21 and 50 buying humongous amount of policies to create a new asset class, which is creating obviously tax-free distributions at retirement. So if a client, if we look at the left side, ladies and gentlemen, if a client takes $268,000 per year and puts it away under 6.7% with his money manager, at age of 65, he'd be able to take $1,106,000 distribution for 9 years. That's cumulative total income paid of $9.7 million. Versus if he takes the same cumulative amount of $5,106,000 at the same rate, keep in mind there is zero income tax on it, he'd be able to take the same amount of distributions for 20 years. That's $22 million. That's a huge difference, ladies and gentlemen, between paying cash versus leveraging. One more example. A second die policy, this is actually an estate planning case. The client purchased this $30 million policy through the Nevada Trust. Their premiums at life expectancy was $8 million. The IRRs, it's $8.1 million, 8.1% at life expectancy over 28 years. Versus they use leverage. At life expectancy, the IRR is 14.4%. The client saved $5.4 million, and that's a 68% cash flow we saved for the client. That you cannot ignore the savings between paying cash versus leveraging it.
So, Joe, you know, when people hear about premium financing, it's oftentimes the first time they've ever heard of it. Why isn't the industry really embracing this in a much more ubiquitous fashion than it currently is? After all the years ago that you came up with this, what's the problem? Why don't more people know about this?
Well, doing leveraging a policy, obviously, it is a high maintenance for the advisors. A lot of advisors, in my opinion, they take shortcuts. They don't want to propose it to a client. However, with an affluent client, and what I consider affluent, $25+ million net worth with good income and good liquidity, if you give the client a choice, number one, obviously the client, first of all, you're going to be saving huge amounts on gift taxes. You have the flexibility either to pay interest or discount the premiums, or you can even accrue the interest down the road.
Imagine no crummy letters when you do an insurance trust when you finance the premiums, because you're not making gifts to the trust every year to make the premiums.
Yeah, it is extremely flexible. However, most of the major carriers, they call us with the gold standard in the life industry, because we are the only firm, I think, as far as I know, that we have renewed through the financial crisis in 08, 09, over $2 billion of premium portfolio.
Wow, that's great. We're going to come back to you in just a second when I get through the Hiset Trust to talk about a case study that you and I worked on. So let me turn your attention now to a very popular trust that we're using out here on the West Coast and around the country. And some of you on the East Coast may have seen something like this called a SLAT, but this is a trust that I think provides a great deal more benefit. I'm going to take you back to the summer of 2010. We'll do a little trip down memory lane. And if you remember, during that time, Congress and Obama were battling over whether the Bush tax cuts were going to be extended. And through the summer and into the fall and good part of the winter, as far as new estate planning goes, we didn't do very much business because we weren't sure what to tell our clients
they'd be able to do. We didn't have any estate tax during 2010. That's the year that George Steinbrenner infamously passed away, and it cost the government $600 million in estate taxes. He was smart going in, and he was smart going out. So December 17th, President Obama signs into law the new bill that unified the estate and gift tax rules and bumped up the exemption amount, gift and estate tax exemption, to $5 million. And this was a euphoric event for us old estate planners, and have been doing this a long time, and the largest exemption amount we'd ever seen was $1 million. And imagine all the planning you can do. But when I got to thinking about how would my clients use this, I mean, we were still in the Great Recession, if you remember, and the idea of giving away $5 million to the kids and grandkids, and in traditional gifting programs, you have to give the assets away and you have no way to get them back, was going to be a very tough sell. And I thought we'd have a very difficult time convincing our clients to do this. And of course, we only had 2 years within which to make the gifts, and the law was going to sunset. So in those days, it was a crazy time for us. But as most things happen, I was doing some accidentally discovered an approach, doing some research for a client that sort of completely changed my thinking. I read a private letter ruling, 2009-44002, which basically allowed a client to set up an asset protection trust in an asset protection trust jurisdiction and have the settlor be a discretionary beneficiary. And in those jurisdictions, as you can imagine, being a discretionary beneficiary, instead of having a general power of appointment, which would have not allowed for a taxable gift, you have a limited power of appointment, which does. And so the IRS ruled that the transfers to the trust were completed gifts for gift tax purposes, and then by extension were out of the taxable estate for estate tax purposes. And I thought to myself, if I can set up a trust and allow my clients to get those assets back if they later needed or wanted them, if they got donor's remorse, or if they just needed the assets, my clients could have their cake and eat it too. And when I wrote that term down on my yellow pad, it spelled Hiset. So I decided to call this trust the Hiset Trust. So in January of 2011, I started having my meetings with my clients. They liked the idea, they liked the concept, and the fact that they can pull the string and get those assets back liberated them to do a lot of the gift planning. And back in those days, we had very depressed assets. So those assets went into these trusts, and we did an awful lot of them. And where this differs from the SLAT is if you do a SLAT and the beneficiary dies, the settlor husband, the settlor beneficiary dies, the settlor husband or settlor wife doesn't have any way to reclaim the assets in the trust. So it does have limitations. So we started offering the Hiset Trust as a solution, and people started pumping money and assets into the trusts. And so here's a little videotape that we put together to help our clients understand the Hiset Trust. If we get this to work. Barbara or Deb, maybe you can help me out here.
We've all heard the expression, have your cake and eat it too. Well, what if you could do that when planning your estate? What if you could take advantage of the generous lifetime gift tax exemption laws by placing your property into a type of dynasty trust, so the asset value grows free of death taxes for multiple generations? Yet, if you later want all or part of the gift back, it's yours. Meet the Hiset Trust. With conventional gift planning, once the gift is made, it cannot be reclaimed. Yet, if the Great Recession of 2008 taught us anything, it's that you can never be certain you have enough money. Let's say you have an estate with property you expect to significantly appreciate and would like to take advantage of your $5 million gift tax exemption. But if your financial circumstances change, how to access the gifted assets? Here's how the Hiset Trust works. You establish the trust in one of the qualifying states like Nevada or Alaska for your kids and grandkids, and use all or part of your $5 million gift exemption to fund the trust to avoid any gift taxes. A gift of $5 million that earns an average of 6% per year will appreciate to over $30 million after 30 years. Wanting to take advantage of the $5 million gift tax exemption, your tax advisor recommends you make a gift of your $5 million to a dynasty trust. You like the idea, but if later you want some of the gifted assets back, you need the flexibility to reclaim part of the gift. How do you access assets already transferred to the Hiset Trust? Under the terms of the trust, you may request your trustee for some of the assets you previously gave to the Hiset Trust, say $1 million of the total of $5 million given to the Hiset Trust. and the assets are set aside in the subtrust and distributed for your benefit. How much will you save in death taxes? It depends on how large the gift grows in value and the then estate tax rate. The current estate tax rate is 40%. If your $5 million gift grows to over $30 million, your death tax savings is more than $12 million. If the assets grow at 10%, your tax savings will be almost $40 million. Worried about lawsuits? How about your child's divorcing spouse laying claim to the assets of the trust? What about bankruptcy or civil lawsuits? With the Hiset Trust, you are protected because your children's and grandchildren's creditors are not allowed to touch the trust's assets. What if your estate exceeds $5 million? Again, not a problem. The Hiset Trust may be used to freeze your estate. You can sell some or all of your remaining assets to the trust for an IOU, and you pay no capital gains tax because the trust is taxed as a grantor trust. While your IOU receives a modest interest rate required by government regulations, the assets you sold to the Hiset Trust appreciate in the trust with no death taxes for up to 365 years. Skeptical? Take a look at IRS Private Letter Ruling 2009-44002 and related favorable rulings. While the PLR may only be relied upon by the taxpayer who requested it, you can see how the IRS treats this kind of planning transaction. The bottom line, you have a choice. Use a conventional irrevocable dynasty trust and lose the power to reclaim the gifted assets, or upgrade your trust to the Hiset Trust and the tremendous flexibility, asset protection, and estate freeze capability of this more robust trust vehicle. That's why we named it the Hiset Trust. You really can have your cake and eat it too.
Okay, so obviously, why use the $5.49 million gift exclusion? Because it'll save your client a whole ton of estate taxes. If I can just get this to, there we go. Over a period of 30 years, those assets grow significantly, and if they grow outside the estate in the Hiset Trust, but your clients have the ability to get them back, it just creates a much easier conversation to have about doing the transfers. Again, it's a multifunction trust, flexibility of the gift, asset protection for the beneficiaries, ability to do a sale to an intentionally defective grantor trust. My friend Steve Oceans wrote about the hybrid DAPT, which is essentially the Hiset Trust, is the most important tool in the asset protection industry, period. It has no equal. And although Steve's not prone to hyperbole, I would agree with him in that case. Here's some of the legal authority that we based the Hiset Trust on. You can read that in your materials. I won't go through it. When I started doing the Hiset Trust in 2011, we were starting to transfer a lot of income-producing assets of our clients into these trusts. So I drove a couple of blocks from here and went to see my friend Julian, and I said, Julian, we have this income-producing assets in these trusts. Can we use the cash flow to really gross up those gifts and to create a better performance for our clients? And he got together with his team, and he came up with a way to do that. So here's a case study that Julian will quickly take you through that will show you how he was able to achieve that.
So the concept, go ahead, Jeff. So the concept was, instead the client just putting the $5 million into the trust, so why not create two asset classes rather than one? So the client already had the $5 million that Jeff recommended to put in a trust. And then meanwhile, we had the trust also borrow another $5 million to purchase the second die policy of around $17 million. So if the client just made the gift, the $5 million at 4% return, let's say over life expectancy, the client's total asset in the trust will be around almost $14,993,000. However, when they use the leverage, they still have $10,886,000 in cash inside the plan, plus $17 million of actual death benefit at life expectancy. So the total will be $28,730,000 versus if you just do nothing and just make the $5 million gift, Jeff, at 4% net after tax, at life expectancy, you will have almost $15 million versus $28 million. And this was, of course, as you recall, it was very custom tailored based on the client's balance sheet and so forth.
And since the client had already decided to part with the assets anyway, this just made perfect sense for them to do this. We could do a whole program, Deb and Barbara, just on this alone. So let me change courses now and talk with you about what I think is the most important part of the presentation this morning, which is asset protection planning. I was a young lawyer practicing about 6 or 7 years when I was hired by a small group of doctors here in my area to do some planning. And they were looking to retire in 5 years. And the longest tail policy they can find to protect them against malpractice suits was going to expire 5 years post-retirement. The problem was that these were baby doctors, and when they delivered their last baby and hung up their stethoscope, they were on the hook for that child's liability until that kid reached the age of 18, plus the then statute of limitations for malpractice claims. So they were going to be in their early 80s before they were out of the woods legally. And they just found that to be abhorrent. And I was tasked with coming up with a way that they can protect themselves in case of a catastrophic lawsuit. And as I took a deep dive into the subject matter, you know, as estate and trust lawyers, we were taught to do planning post-mortem. We want to pass as much wealth as we can to the next generation and keep the administrative functions as smooth as possible. We never thought about the fact that a person might get sued during their lifetime and lose all or most of their wealth. So when I finished this planning for this client, and by today's standard, it was a pretty basic plan, it got me thinking about what was my more important function in the estate and gift tax planning role for my clients, making their kids or grandkids richer, or building these firewall protections for my clients and protecting them against a future potential financial catastrophe, legal catastrophe. And so I retooled my practice and changed my approach to my estate planning, and we would sit down and have an adult conversation about lawsuits and planning before we got started talking about estate and gift tax planning, because I can design the most elegant estate plan, but if the client gets sued and loses all of their wealth, my plan isn't worth the paper it's written on. So asset protection planning became part of our lexicon. This is now going back 30 years, and I dare say while the industry has grown and there are some excellent planners, it's still a long way from capturing the majority of the clients, and most estate and trust firms don't recommend or don't even get into this discussion. So your clients can be successful investors, you can have successful tax planning, but they can all get wiped out. It won't matter if they get sued. So it's really not about what you do, it's about what you own, and I can prove this to you. Get battered, get injured, have property damage by a homeless person, and call up, well, the king out here is Larry H. Parker. I don't know how it is the rest of the country, and try to get a contingency fee lawyer to take your case. And if that defendant doesn't have any assets, you're not going to find a lawyer no matter how good the lawsuit is. So it's not going to matter as a practitioner if you wind up getting sued and you lose everything that you've accumulated over your lifetime. And for those of you that work in the estate and gift tax area, if your laws are like they are here in California, we're not out of the woods until the testator we do the will for passes away, and then 1 year from his death, the statute of limitations expires. So we could be well into our 80s and 90s before our liability ceases. So that's why asset protection planning is on our radar screen. If your clients don't know they have exposure, there's a lawsuit exposure test I put here on the screen. Have them take this test. If you would like to get this test on in Word and put it on your letterhead, I'm happy to send it to you. And if they score on the rather high end of the answer key, they're probably grand candidates for asset protection planning. Now, there's a big debate right now in academia as to whether or not asset protection works. I spoke at the 2014 Notre Dame Institute, and just before I came on, Jeff Pinnell, brilliant academician and writer and lecturer and professor, spent an hour talking about asset protection planning maybe not being so effective, but nobody ever defines the term work. In my world, in our practice, the term work means that by putting these structures into place, the client has a much better chance of achieving an early and more favorable settlement. And it's obviously important to manage your client's expectations about what they expect asset protection to do for them. But here on the left side of the screen, you can see half a dozen or so cases where we've used asset protection planning to achieve, which by, my metric is a pretty decent result. $58 million lawsuit settled for $7 million, a $34 million malpractice suit settled for less than $1 million, One interesting case I'll just spend a quick second on is a client had a personal guarantee and a bunch of heavy equipment. They had a recession. He couldn't pay for it. The creditor got a judgment against him. But we had set up a series of limited liability companies for him as part of his estate plan. And so the creditor got a charging order against the LLC interest. A charging order is the enforcement remedy for partnerships and LLCs, and basically had a lien against the partnership interest, but no ability to go into the partnership or the LLC and to reach the assets. We sent the K-1s every year to the creditor because under Revenue Ruling 77-137, the assignee partner is the partner that picks up all items of deduction, credit, loss, and expense. And so for the first couple of years, there wasn't much activity in the partnership or the LLC, but then they sold a very valuable piece of real estate, and there was a $2.3 million gain that got attributed to that charging order. We sent the K-1 to the client that year, or to the creditor, excuse me, and quickly we get a phone call, and the case settled for $250,000 because they didn't want to have to go through this every year going forward. So we've had some very good results, and I think if you begin to implement asset protection planning with your clients and situations arise in their world, they're going to be able to use these tools to be able to effect a quick and favorable settlement. When thinking about doing asset protection planning, there's two approaches. One is domestic asset protection trusts, and of course the other is the offshore asset protection trust, made famous by Barry Engel from Denver, Colorado. When you think about which direction to go, I mean, we've now seen 17 states have adopted self-settled trust legislation once the international community began to embrace this, because I think many of the states saw their business going overseas. But the problem with domestic asset protection planning is we get this document called the U.S. Constitution, which sort of gets in the way, and we've got concepts that trump state law. Full faith and credit clause, the supremacy clause, the contract clause. These concepts, federalism trumps the state laws, and so until we see some U.S. Supreme Court case law coming out, I'm just a little bit dubious about how effective domestic asset protection planning is going to be. Now, my good friend Steve Oceans will tell you that there's never been a case. Come on. Barb, Deb, can we advance the slide? Thank you. There's never been a case that's been decided against a domestic asset protection trust or punctured a domestic asset protection trust. Thank you. But I think that speaks to the fact that when creditors are faced with asset protection cases and there's no fraudulent transfer involved, they'll typically settle versus litigate without the prospect of recovery. But there's a relatively new statute, the 2005 Bankruptcy Act, has a 10-year set-aside rule for transfers to self-settled trusts, there we go, or other similar devices. And there's a couple of cases now that have been decided under the statute. Henry Mortensen, a case out of Alaska, in which an Alaska resident set up an Alaska asset protection trust, and yet the bankruptcy trustee still went after him for transfers, claiming that the fact that he set up an asset protection trust was evidence that he had the intent to hinder, delay, or defraud a creditor. That case was on appeal to the Ninth Circuit, and then the parties settled. And then you have Henry Huber, where this is just a bad facts making bad law case. This is a case of a Washington resident who set up asset protection trusts in Alaska, had no nexus with the state, and it was just bad timing, and the result was the way it should have happened. But it's just always difficult when you're trying to decide what's the most protective way for your client to go. Domestic asset protection, like Nevada or Alaska or offshore, if you want more predictable results, the solution is to establish your trust in a jurisdiction that doesn't have any comedy with the U.S. And one of the most important things that we do in our world is forum shop, finding the best jurisdiction to set up trust. When it comes to the Hiset Trust, we find that Alaska and Nevada are great jurisdictions for this. When it comes to asset protection planning, having done it as long as I have and been able to achieve the results that we have, we find that going offshore gives our clients a great deal of protection. But for those people who just are not comfortable going offshore, setting up a domestic asset protection planning, a trust rather in either Alaska or Nevada is a good alternative. So you can see the advantage of the foreign trust versus domestic trust, increased ability of settler to retain the benefit and control. Foreign trusts less likely to be an automatic target of litigation because of the challenges of litigating a trust overseas, and you can go on and read the rest of these. So it really, it's a question of good, better, or best. I like the foreign structures for asset protection planning because they're almost inviolate, but for most clients doing a domestic asset protection trust who don't find themselves getting into a bankruptcy over the next 10 years may be an effective alternative. Okay, I've got a little specialty for those of you that reside here in California. This doesn't apply around the country. We're the only state in the country that has this, but this is the best asset protection plan that those of us who practice in California have never heard of. What is it? It's called a private retirement plan. California is not known for its exemption laws, to be sure. But we do have this one little gem in our statute, California Civil Code of Procedure 704-115. And this statute says that if you establish a private retirement plan, that assets that you contribute to the plan are fully exempt from creditors, even in bankruptcy, because California is opted out of the federal bankruptcy exemption regime. And then more importantly, when you take your retirement distributions out of your plan, then those distributions are similarly exempt. And the plan does not have to be ERISA qualified. So for those of you who want the protections of the private retirement plan, but don't want to have to include other employees, don't want the funding limitations that you have with ERISA qualified plans, you can set up basically a defined benefit plan, but just not ERISA qualified, and you get the ability to do the discrimination that most owners would prefer to have. How is it established? The employer sets up the plan for the employee. It's an employee, it's taxed as an employee grantor trust, so all the income tax benefits or all the income tax incidents flow to the employee. But once the plan is established and you've established how much of a retirement benefit the employee wants to receive, then the employee contributes his or her assets to the plan to make sure that there's sufficient assets to be able to provide that benefit. Once those assets go into the plan, they're exempt from creditors, even in case you have to file for bankruptcy. And when those plan distributions come out, they're protected as well. For those of you that have any interest in this, you can go on my website, www.jmblaw.com, and there's a video I have on this. There's some materials on the private retirement plan that you may want to take a look at. So we have a big toolbox in the way that we approach estate planning with asset protection, comprehensive estate planning. It's just a question of which of these tools is appropriate for the client, for their budget, and what they're trying to accomplish. I publish a client alert, usually about once or twice a month. And if you'd like to sign up for the complimentary client alert, I'm happy to just send me your contact information, and you'll be getting that sent to you from Peak Trust. Just send that in to us, and we'll make sure that we get you on the list. I've written a book called Estate Planning for Women Only. I do lectures on luxury cruise ships a few times a year, and I do a program called Estate Planning for Women Only, No Men Allowed. We don't let the men in the room, it's just the gals and me, and we have a very frank discussion about all the challenges and frustrations that the wives go through when they try to put estate plans together, particularly when you're dealing with the his, mine, and ours situation. And I cover in my book the basic estate planning and some of the more advanced things, including the premium financing topic that Julian talked about earlier. If you'd like to get a copy of the book, it's on Amazon, and we donate our profits on the book to the Wounded Warrior Foundation. So it's our feedback form, and I guess at this time, Barbara, we'll take some questions.
All right, that sounds good. And this is actually Deb, Jeff, and we do have a question that came from Mr. William Schroeder. And the question is, are you concerned about the potential end of the estate tax in the USA? How should clients adjust their documents?
Well, that's a great question, and that's the penultimate question. But I think if you take a look at the Trump's tax plan when he was running as a candidate, the concept was to repeal the estate tax, but replace it with a Canadian-style capital gains tax. So I still feel that if you want to avoid the triggering of the capital gains tax, and this capital gains tax will have a similar, $10 million exemption for couples. The capital gains tax rate will probably be half of what the estate tax rate is, so it won't be as draconian, except if you have a large estate. But if the idea is to delay the recognition of that gain, then get those assets into these dynasty trusts now before there's a liquidity event, or before death arises, so that doesn't trigger the recognition event. So I still think dynastic trust planning is important, whether we have an estate tax or whether we have a Canadian-style capital gains tax.
Okay, well, thank you, Jeff. The next question is regarding private financing, so I'm assuming this will be for you, Julian. Are all the more favorable numbers guaranteed or projections? And also, what type of life insurance are you using? That's two-part.
All the policies that it's been leveraged since 1995, they have to be permanent policies, so they don't expire. So either got to be traditional whole life policies or universal life or index universal life policies. So then the whole life policies, obviously you have guarantees, and the index universal life, you have principal protection, with a floor of 0 and a cap of 10 or 11. It depends which carrier the advisors would like to use. So that's on the product side. On the loan side, of course, some clients, they want what they call adjustable rate. Some clients, they want the fixed rate. So that's all up to the advisors.
Okay, thank you, Julian. Hopefully that answered all those questions. And we do also, Paul Remack, if you're there, I'm going to unmute you. You have raised your hand that you have a question. Paul Remack.
Good morning, Paul.
Okay, we must have had an issue connecting. Sorry about that, Jeff. And there was another comment from Steve Welsh after you mentioned your comments regarding the potential repeal of the estate tax. Steve says Trump is a negotiator. He will likely trade it away. And his comment is, I'm betting that we'll have a higher estate tax when the bill passes, if it does. Any comments on that?
This has been like an alternative universe the last 6 months. So I wouldn't be surprised at anything. I was surprised the budget today didn't have the money for the wall. It didn't have. They funded certain things they weren't supposed to fund. But running a government's a lot harder than running a business, I would imagine. And they got smart people up there. They'll figure it out. But I do know this: it'll create a lot of work for us in our industry, and I'm all too happy for that.
Well said. And Paul Remack, Jeff he emailed his question here. Paul asks, assuming the estate tax is replaced by the Canadian approach for California taxpayers, will there be tax savings since California taxes gains as my glasses on, OI?
Well, this is where a great firm like Peak Trust Company comes into play, because when people start looking at the kinds of tax rates, and California right now is at 13.3, but I think it's going to be going up. California can't afford to offer all these services to its citizens and its non-citizens and be able to pay its bills, because we're losing a lot of the income producers to other states. So I think when we look at tax planning for California residents, instead of leaving this beautiful state, which it is, with this beautiful climate, just move your assets out of California and have the gains attributed to in states like Alaska or Nevada, where you don't have an income tax or a capital gains tax. And I think you can achieve some significant benefits by doing those analytics. And maybe that's something we can talk about in another program. Deb.
Yep. And thank you, Jeff. As always, Peak Trust, we appreciate that little plug you gave us there. William Schroeder has a couple more follow-up questions for you, Julian. What is the collateral for the insurance loan? Any personal guarantees?
No, the personal guarantees, usually we can waive it. That's easy. And the rule of thumb with us, if a client is going to borrow, an example, $5 million, the rule of thumb, we require collateral somewhere between 8 and 12%. That's the required collateral.
For how long?
And the collateral, it's temporary, and usually it depends on the product that the advisor chooses to use. The collateral usually will release the collateral after 5-6 years. Having said that, the collateral can stay with the client's money manager, it never moves. We just file a security agreement. So only time that collateral is at risk if the client is in default. And usually we don't have any defaults with the type of the clients that we have.
Okay, and then he's got kind of a couple more follow-ups kind of to that. So I think you might have answered this, but he asks, is the collateral for the loan just the policy value, or does the trust have to act as collateral, or is there any personal guarantee that may be needed? Julian?
No, the personal guarantee, the trust usually is the borrower and the owner of the policy. So the trust usually do have assets. And again, the trust is pledging the collateral, the temporary collateral that we need. And again, I'm not sure if you're asking the question about the percentage of the collateral that we require. Usually it's between 8 and 12% of the total cumulative loan.
And one of the reasons it's so low is because the policies have tremendous cash values. And why would that be, Julian?
Well, one of the key, when you're designing large amount of life insurance, one of the keys that we've learned in the early 2000s, then in 2008 and 9, when we had the financial crisis, we want to make sure we built enough safety nets for the client. So if the client ever changes his mind and he wants to exit, we want to make sure the client doesn't have to write a $5 or $10 million check. So the cash values, the way we structure it, are the safety nets for the clients.
But aren't you taking your commissions and spreading them out over a longer period of time so there's more cash value in the policies, and so you kind of have skin in the game along with your client? If you don't service the policy and take care of them, they're going to drop you.
Well,
that's unusual in the industry.
And again, you are correct. We are correct. We want to make sure the client, again, has the right design that's going to work for him. Number one. Number two, again, my biggest concern with other advisors that they come to us, we want to make sure that we built enough safety nets for this client, again, if something goes wrong with their financials. So we don't want a client writing a $5-10 million check. If they ever decide to exit the plan, the cash values will cover 95% of the note after 3-4 years.
And I can tell you from personal experience that we started implementing the Hiset Trust with the finance life insurance back in 2011, and the performance of these policies, even through the ups and downs of the economy, have been almost spot on to what you projected in the illustrations when you sold the client the policy. So that's reassuring. They haven't had to put up any more capital into the policy.
Nope.
Okay, what else?
All right. Just one more kind of a follow-up for you, Julian, as a kind of a third part is, or maybe this is for you, Jeff. What is the income tax rate on the income produced in the trust in that case?
Well, the trust is a grantor trust, so it's going to be the income tax rate of the state of the grantor. But one of the nice things about the insurance policy is because life insurance policies don't pay tax on their capital gains, interest, dividends, or royalty income, it's a great way to create tax efficiencies. And then when the client gets 15, 20 years into the program, the policies have built up substantial cash value. The trustee can borrow the cash value out of the policy and make loans to the taxpayer. And those loans create a liability from the taxpayer back to the trust. And when you accrue the interest and you have this loan, when the taxpayer dies, that creates a deductible expense or a liability in the estate under Section 2053, and Uncle Sam winds up subsidizing, 40% if that's the estate tax rate. Then, if we have an estate tax of that liability, so there are some wonderful planning opportunities. And again, we could spend an hour just going through case studies, showing how once you get the asset out of the estate in the Hiset Trust or other dynastic type trusts, how combining that with a life insurance policy really does gross up the amount of wealth that's being created with modest risk and creating tremendous amounts of tax-free buildup in cash value, which is why so many younger people are dumping so much money into these insurance policies.
Using bank money, actually, not their money. Right.
And people don't do premium financing because they can't afford to borrow the money or they can't afford to pay the premiums. They do it because it's just a better, more efficient way of leaving their assets in their portfolio or in their business and using the bank's money to create this secondary asset.
And thank you. We've got about 5 more minutes and about 4 more questions. So we're going to do the best we can here. Here's a question for you, Jeff, is how do you move trust jurisdiction from California to Nevada, for example, in order to decant and guarantee California won't attempt to avoid that move from California to Nevada? And the second part of that is, what if the trust explicitly states that California law shall apply?
Well, that's good questions. If the trust allows for a change of situs, and most well-drafted trusts have this provision, it's very easy to move it. The trustee has the authority to move it from California to Nevada. And if it's a grantor trust, California will still collect its tax. If it's a complex trust or a non-grantor trust, then California will not collect the tax unless the distributions come out to a California beneficiary. So that's manageable. But that's how you get the trust into a decanting state, whether it's Nevada or some other state that has adopted this law. The second question was, one more time, Deb?
The second question was, hold on. Oh,
Sorry.
Mike. Nope, no. That came from Mike Kling. Hey, Mike, do you mind typing that back up? My apologies. It's not on my screen now. We'll come back to that. And I'll jump ahead to another question. This is from JJ Moline. Do you have any experience with the Hiset and real property gifts to leverage Prop 58's parent-child exclusion? Specifically, have the assessor's offices raised any issues?
Good question. So whenever you do a transfer of California real estate into an irrevocable trust, you have to make sure that you don't run afoul of the reassessment rules unless you want to. There may be times when you want a reassessment. And so if you do it carefully, you have the parent-child exclusion, you've got the exclusion of transferring an asset into an LLC, or we typically do them, we first transfer them into an LLC or a limited partnership before they go into the trust so they can get a discount. And so you just have to be careful that you're not running afoul of the rules and stay within those guidelines, but it can be done.
Okay, perfect. Another question. I think this might be for you, Julian, again, and we'll try to take. It's kind of a 2-part question, and then after this, anybody that's got questions, we will follow up with you and we will have these answers, but we will send them via email. The last question we can take is, can a C-Corp purchase life insurance for 100% owner? And then can they deduct the cost and name any beneficiary they want, or does the beneficiary need to be the C-Corp?
All right, a C-Corp, yes, they can purchase the policy. However, the cost is not deductible. That's after the corporate CPA or CFO to decide that. But in my book, no, the cost, it is not deductible.
That's correct.
Okay, and then the second part to that is, why is it better to register a living trust in a state other than California? And can a resident of California qualify?
Right. So if you go on my website, I've written 3 articles in the last couple of months, one for Kiplinger, which I think how you and I got connected, Deb, and 2 here in California about why California is probably the worst place to have a trust. We have laws in our state that allow, if you set up a support trust for your kids, we have laws in our state that allow your kids' creditors to invade that trust and disregard the spendthrift clause, which is something that's so, endemic, so inherent in the ability of one to set up a support trust and keep one's creditors away one's children's creditors away from the trust. So we just have a philosophy here in California that, they don't want people doing things that's going to affect society in a negative way. And I think if you want to set up a trust and you don't want your kids' creditors to reach it because, our children are making mistakes, I think you should be allowed to do that. That's the way trust law has been since, for 1,000 years. And yet California is trying to rewrite that whole concept. So selecting a situs outside of California is certainly something that one can do, and it's done all the time. And you just follow the rules, and you should have no problem in affecting a better result. That's why we like Nevada so much.
Can I add one more thing, Deb, if you don't mind? Because
No, of course not. Of course not.
I'm mentioning one thing. We get a lot of calls from all over the country, from attorneys, CPAs, financial advisors, that they have clients that are paying those large premiums on existing policies in cash, and they ask us, can we help them? And the answer is yes, we can. They don't have to cancel their policies. However, we restructure their premiums. By doing that, obviously the clients will have some huge advantages. So I just want to mention that because I know a lot of the attendees, they do have clients that are paying large premiums, possibly they don't have enough crummy powers, or they're paying gift taxes, or so forth. Right.
Okay. And thank you, Julian. So I'm going to invoke my right to change my mind. So if my husband, you're listening out there, this is not unusual. And I'm going to grab we just have 3 last questions. So are you okay with that, Jeff and Julian, if we just, okay. Mike Kling, thank you. Mike Kling did get back to us. And the last part of his question, Jeff, what of the trust explicitly states that California law shall apply? That is, it doesn't allow for a change of situs.
Yeah, if the trust is irrevocable and it doesn't allow for change of situs, you'll have to go into the Superior Court and get a court to issue a modification of the trust, allowing it to be moved. And the judge is probably going to want to be very clear on what the trustor's intent was. And if it's not clear that the trustor would have allowed this, or the settlor would have allowed this, you probably won't be able to move the trust. So possibly having the trust sell assets to a trust in Nevada, or an installment note, or some other technique like that to move the assets into the right environment might be one of the solutions to a trust that doesn't allow for it to be moved. And Mike, if you want to talk about that, give me a call at my office and we can brainstorm a little bit.
Okay. And then Stephen Welsh kind of has a follow-up to that. He just makes a comment that says you could also create a new trust in Nevada and perform a statutory merger or a private merger if the trust agreement permits.
That's right. And again, if it's a well-written trust, it's probably that language is in there and authorizes the trustee to do it.
Okay. And then sorry. One last question from Stan Kimball. This is for you, Jeff. If I understand correctly, Jeff is using more foreign asset protection trusts. If so, what jurisdictions?
Yes, I'm using more foreign asset protection trusts for pure asset protection play. I set up my Hiset Trusts in the state of Nevada. I like the Cook Islands because I've been setting up trusts there for over 20 years, and it's performed as advertised. We're now setting them up in the Bahamas because last December they changed their fraudulent transfer laws and really tightened that up. And then we like Belize because Belize has a very interesting trust statute. It doesn't have a fraudulent transfer statute, so you literally can set up a trust in Belize and not even have to deal with fraudulent transfer as it relates down there, not necessarily here in the States. So those are my 3 go-to jurisdictions: Belize, the Bahamas, and mostly the Cook Islands.
Perfect, and thank you. And I think we've only gone 4 minutes over. I think we did pretty good. So with that, I want to thank Jeff and Julian so much for your time today. We've gotten all kinds of thank you emails out here that we'll share with you. And thank you for all the attendees for hopping on today. We greatly appreciate your attendance and want you to know that we will be following up with all of you with an email with a copy of this slide deck and also a copy of the recording. So thank you, everybody, and have a wonderful rest of the day.
Thank you, Deb. Bye-bye. Bye.